Principal seat matter for delivery of judgment. Item 1, make appeal 904 of 2018.
For reasons mentioned in the judgment, the impugned judgment to the extent of attributing contributory negligence to the driver of the Ford Figo car is hereby set aside. As such, the insurance company is liable to pay entire compensation amount of rupees 67,12,000 to the claimants. The insurance company shall deposit the said amount before the registry of the principal seat within a period of 4 months, 4 weeks from the date of this judgment, and on such deposit being made, same shall be disbursed to the claimants after proper verification.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 2. Lordship, here I'm appearing for respondent number 8. However, I'm mentioning on behalf of Mr. Sharif Ahmed, the counsel for respondent number 1 to 7. He has been trying to appear through VC, but due to bad internet connection, he could not appear. Lordship, he's not keeping well, so he has requested the matter to be listed after
Sharif
4
Ahmed
weeks. Appearing for respondent number 1 to 7. I'm appearing.
Heard Ms. Loshino, the learned counsel for respondent number 8, who submits that the counsel for respondent number 1 to 7, Mr. Sharif Ahmed, has intimated her to pray for an adjournment on the ground of his personal difficulties. The prayer is not opposed to by the learned counsel for the appellant, hence same is allowed. Let this matter be listed after
4 weeks, my lord.
4 weeks on a date to be fixed by registry.
Oblige me.
Wait, please, Lordship. I beg to mention item number 1. I have received the additional affidavit filed by the respondent number 1. Your Lordship may kindly grant me 3 weeks' time to file a reply.
But Ms. Mabeni,
Menosheno.
sorry. What is your name?
Menosheno. I'm appearing on behalf of Arirano.
Minushima, appearing on behalf of Mr. R. Iralu, learned counsel for the petitioner. Also Ms. B. Shokri, learned additional AG. It is submitted by learned counsel for the petitioner that she has received the affidavit filed by the
Additional affidavit.
additional affidavit filed by the
Respondent number 1.
respondent number 1, and would be filing a reply against the same, and for that some time is prayed for. The prayer is not opposed to by the learned additional AG, hence same is allowed. How much time?
3 weeks' time.
Let this matter be listed after 3 weeks on a date to be fixed by registry.
Oblige.
May I please, Your Lordship. Your Lordship, I beg to mention item number 3. Lordship, my seniors in disposal, kindly list the matter after 3 weeks, Lordship.
Heard Mr. Toshi Temjin Pongena, the learned counsel for the respondent, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for respondent number 3. Also heard Ms.
Hombeni Izung for respondent number 3.
What is your name?
Pim Hombeni Izung for respondent number 3.
Write her name. Appearing for respondent number 3, as well as Ms.
Litosu.
Alito Su appearing for the petitioner, who does not have any objection to the prayer made by the council for the respondent number
2, Lordship.
2. Hence, the prayer is allowed. Let this matter be listed after
3 weeks.
3
Lordship.
weeks.
Much obliged.
Wait, please, your lordship. I beg to mention item number 5. Lordship, as per the court's order dated 14/7/2026, service upon the respondent is still awaited. So let the matter be listed after 3 weeks.
What is your name?
Rebecca. Rebecca.
Rebecca.
Lordship.
Third, learned counsel for the appellant/applicant. Also, Mr.
No one saw for R1.
Write his name. What is your name?
No one saw for R1.
Re- What is the spelling? Spell out your name.
NO
N-O,
NGO
no,
NONGOSA. For R1.
respondent number 1. On perusal of the office note dated 14/7/2026, it appears that the service report in respect of notice issued to which respondent?
3 and 4.
Respondent number 3 and 4 is awaited.
2 and
Yes. 2 and 3 is awaited. Stop, await further. List this matter again after
3 weeks.
3 weeks.
Please, Lord.
Lordship, I also beg to mention item number 8. Lordship, service upon the respondent has been returned back due to insufficient address. So let the matter be listed after 3 weeks, and in the meantime, we'll find the correct address.
Heard Miss Rebecca, learned counsel for the applicant/appellant. On perusal of the office note, it appears that the notice is issued to the respondents. Respondent number
2, 3.
2 and 3. You have gone through the 2 and 3 have returned without service. She submits that some time may be granted to the applicant/appellant to find out the correct address of the respondent number 2 and 3, and thereafter to take fresh steps for issuance of notice on the said respondents. The prayer is allowed. The appellant/applicant shall take fresh steps at the proper address of the said respondent by speed post as well as by usual mode within 15 days from the date of this order, returnable after 4 weeks. List accordingly.
Much obliged.
May I please, your lordship, I beg to mention item number 7. Lordship, I'll be representing, respondent number 2 and 3. We're yet to file our baklat nama, so if 2 weeks time may be granted to file my baklat nama.
No objection.
Heard
I'm
Mis-
for respondent number 6, my lord.
heard Mr. Z. Kulnu, learned counsel for the appellant. Also heard Mr. V. Devnath, learned counsel for respondent number 6. What
Lordship.
is your name?
Medokiki.
Also heard Ms. Medo Kiki, learned counsel, who submits that she has been instructed to appear for respondent number 2 and 3 and would be filing the wakalatnama shortly, and as such has prayed for adjourning the matter today. You are appearing
Your
for?
Lordship, I'm appearing for respondent number 1. We have filed our baklat nama yesterday, Your Lordship.
What is your name?
Is Chilean.
Write her name. Learned counsel submits that she is appearing for respondent number 1 and has filed the wakalatnama yesterday. Stop. Let this matter be listed again after 3 weeks.
Much obliged, Lordship.
Much obliged.
From the supplementary cost list for motion, item number 9.
Yeah, please, your lordship. The petitioner is running a
Just.
petrol pump outlet in Kohima. It is just before reaching Kohima, lordship may have just came across while coming to Kohima, just before reaching Kohima, it's on the right hand side. In 1990, it was allotted, and in 2013, the terms and conditions of the agreement with the Internal Corporation has been renewed, and then detailed terms and conditions have been laid down. And since then, they are running since 1990. Earlier, there was agreement, and then it was renewed in 2013. And then equipments, whatever is necessary, are provided by the manufacturers through company, and then it is being fitted. Nowadays, lordship is aware, everything is computerized. So I cannot do anything, or any other person can also not do anything. Whatever is fixed component, it will be fixed and fitted. Now, periodic checks are being conducted by the Legal Meteorology and Consumer Protection Department. That is the nodal department in the state. Periodically, the Indian Oil Corporation will also conduct periodic checks. That is for the last 35 years, they have been doing that. And the last check conducted by the Nagaland State Legal Meteorology and Consumer Protection, they have conducted a test on 2nd April 2026, and they have given a clear chit. And the next test to be conducted is in the early part of 2027.
What test? To test what?
Test everything, quality of the petrol and the quantity of the petrol, everything is being checked.
Okay.
And then again, in the month of May this year, 11th of May, a joint verification check was also conducted, both by the Internal Corporation as well as by the Legal Meteorology and the Consumer Protection Department. And there was no adverse finding during that check also. It was on 11th of May 2026. That is the last check, and nothing was found at first during that check. But what happened on 18th of June 2026, the petitioner received a fake finding report from the Internal Corporation, and then reasons have been assigned there that there is some discrepancy and some sort of a manipulation is there. 10 days time was given in December, and 10 days time was given to reply to the said fake finding report. Accordingly, the petitioner has submitted a detailed reply on 27th of June 2026. And the petitioner was expecting that his reply will be duly considered by the authorities. But as a ball from the blue, on 29th of July 2026, that is just last week, the petitioner has received the immune show cause notice from the Indian Oil Corporation, and I have to reply within 15 days. If I fail, then cancellation and other penal provisions will be there. My grievance is, lordship, for the last 35 years, I'm running the petrol pump without any blemish record. And this is the only means of livelihood for a petitioner. And with all litigation, he is running this pump. And then detailed reasons have been given in the reply. on 27 June 2026. Without considering the reply, mechanically the respondent authorities has issued a show cause. I'm agreed by that. And-
Where is that show cause?
Show cause notice, Lordship will find it page 94. And the operative portion, because it is a lengthy show cause notice, this is just a duplication of what is there in the fact finding committee. Just mechanically, they have elaborated a bit from the fact finding report, and then show cause notice was issued. With a closed mind, they have considered my reply. That is how I'm agreed, Lordship. 101, third, from the bottom, it is from the third paragraph, Lordship, just below the word unquote. There are 3 paragraphs where stringent penalties and then provisions have been shown. And had the authorities considered my written reply on its proper perspective, this show cause notice would not have. They have already prejudged. And I have reasonable suspicion that the authorities have issued with some ulterior motive also.
No, but you have been given 15 days time to respond to.
Lordship, it will be an empty formality only because
How you know?
from the language of the show cause notice, it is nothing but a duplication of the fact finding report, which I have replied. And had my reply been considered, then this could not happen because I have given all the justification with material evidence also. But they have not taken into consideration of that thing. And there is nothing in the show cause, even a whisper, there is nothing, even not even a whisper in the show cause notice about the consideration of my reply. How it is not acceptable, why it is not acceptable, nothing has been shown. So any further proceeding will be an empty formality. And Lordship is aware, even the best medicines will be of no value if the patient is dead. So any treatment, any medicine is required
But till you
during the lifetime of.
till you are alive, you have to take medicine. If you are ill,
That is why
you are refusing to take last medicine.
That is the reason why I need the best tablet from this honorable court, so as to
We'll
cure
give
my
you
ailment.
protection, but you reply to show cause notice.
Lordship,
You
there are
cannot say that
cases.
you will not reply. You reply, the apprehension will be taken care of by this.
Whatever Lordship is saying, I fully agree. In a show cause, this honorable court normally may not interfere. But there are exceptions in such a situation.
Now, why are you apprehending that they will take action?
Because from the show cause, whatever reply I have given in the fact finding, in response to the fact finding, the same has been reflected in the show cause notice.
Your reply dated 27/6
Yes,
has not been considered.
yes. There is not even a whisper in the show cause notice how they have considered and why it is not acceptable.
And why the
All
necessity-
detailed explanation I have given to the fact finding report.
Mr. Angami, you are appearing for somebody.
Yes, Your Lordship, state is a pro forma respondent, 2 and 3 here. The main party is the Indian Wool
But-
Corporation, Your Lordship.
Correct.
Heard Mr. C.T. Zamir, learned senior counsel, assisted by Mr.
M. Kong Chamir.
M.
M. Kong Chamir.
M. Kong Jamir, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government counsel, appearing for respondent number 2 and 3. This application under Article 226 of the Constitution of India has been filed by the petitioner, namely Messrs. Avili Service Station, represented by its proprietor, Avili Shekoshe, impugning the show cause notice bearing reference number TDO/MDG/160-154/SCN/1 dated 29/7/2026. The learned senior counsel for the petitioner submits that the petitioner is an authorized retail outlet dealer of respondent number 1 company, that is Indian Oil Corporation Limited, carrying on business of sale and distribution of petroleum products in Kohima since the year 1990. He submits that the dealership agreement of the petitioner's service station was extended by executing a new agreement on 15/1/2013, which is still continuing. He further submits that since 1990, the petitioner service station has maintained an unblemished record without any record of any allegation of adulteration of petroleum products, short delivery, manipulation of dispensing unit, tampering of statutory seal, or any other malpractice. He submits that the respondent number 1, what happened on 2/4?
Pardon, well,
On 2nd of April, what happened?
Yes, 2nd of April was the test conducted by the Local Meteorology and the Consumer Protection Department to check the quantity of the petrol and the quality of the petrol, and it was found valid. It is there in the page 48, Annexure P. I have enclosed
He
the report.
submits that on 2nd of April 2026, the Legal Metrology and Consumer Protection Department of Government of Nagaland, that is respondent number 2 herein, inspected the equipments installed in the petitioner's service station and were duly verified to be intact, and accordingly verification certificate was issued to that effect by the competent authorities. He further submits that on 11/5/2026, next para, he further submits that on 11/5/2026, a joint verification of petitioner's retail outlet was conducted by the officials of respondent number 1 corporation in the presence of the officials of respondent number 2 and 3. After the said verification and after collection of the laboratory reports of the sample collected during the said verification process, no disclosure of any adulteration or contamination or deviation in quality of petroleum products supplied by petitioner's retail outlet was reported or found. The learned senior counsel for the petitioner submits that, however, on 18/6/2026, the petitioner received a letter, a fact-finding letter issued by the respondent corporation alleging certain technical observations made by the original equipment manufacturer during the examination of components made by the original equipment manufacturer. Stop. Therein some allegation of manipulation of delivery of fuel and other deviations were made, and the petitioner was directed to reply to the fact-finding letter within 10 days. Accordingly, stop. He submits that accordingly on 27/6/2026, the petitioner submitted a comprehensive reply again answering each of the allegations contained in the letter dated 18/6/2026 received by him, wherein the learned senior counsel for the petitioner submits that the petitioner categorically denied having carried out or authorized any tampering, manipulation or unauthorized alteration of the dispensing unit and placed before the respondent authorities all relevant materials, including statutory verification certificates, inspection history, preventive maintenance record, etc. He submits that, however, on 3 days, on 29/7/2026, the petitioner received a show cause notice wherein it was alleged that the petitioner has violated the terms of clause 5.1.4 read with penalty clause 8.2 within bracket Roman 4 of the marketing discipline guidelines within bracket MDG 2024, as well as certain other clauses of the dealership agreement dated 15/1/2013. The learned counsel for the petitioner submits that, learned senior counsel for the petitioner submits that the contents of the show cause notice dated 29/7/2026 received by the petitioner itself indicates that the respondent authority have not applied its mind to the reply submitted by the petitioners on 27/6/2026 against the fact-finding letter dated 18/6/2026 received by it, and without considering the reply of the petitioner, have again reiterated the facts which were alleged in the facts finding notice dated 18/6/2026.
2026.
Learned senior counsel for the petitioner submits that though the petitioner is ready to respond to the show cause notice which has been impugned in this writ petition, however, he apprehends that it would be mere formalities as the respondent authorities have not applied its mind on the reply dated 27/6/2026 by the petitioner before issuing the show cause notice. He submits that the tone and tenor of the show cause notice indicates that the respondent number 1 company is likely to take coercive action against the petitioner's firm, which may include the termination of dealership agreement and other action. As such, he has prayed that notice may be issued to the respondent number 1 corporation, and in the meanwhile, some interim protection may be granted to the petitioner's firm. Stop. Issue notice to the respondents. Since Mr. N. Angami has already appeared for respondent number 2 and 3, no formal steps for issuance of notice or upon said respondents is required to be taken. However, the petitioner shall furnish requisite numbers of extra copies of the writ petition along with the annexures to
The
learned,
course of the day.
to learned senior government counsel during the course of the day. As regards respondent number 1 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of September. 8th of September, stop. In the meanwhile, considering the submissions made by learned senior counsel for the petitioner as discussed in the foregoing paragraphs of this order, the respondent number 1 company is directed not to take any coercive action in terms of the show cause notice dated 29/7/2026 issued to the petitioner till next returnable date, list accordingly.
Obliged.
Obliged, Baba.
For admission, item number 4.
Very pleased, Your Lordship.
Yes.
Lordship, in the last occasion, respondent number one sought 3 weeks' time to file affidavit. However, today they are not present today.
3 weeks have lapsed.
Yes, Lordship.
Who is respondent number one? State.
Respondent number one is my former wife.
Oh, what is the matter?
Lordship, by filing this petition, I'm praying to question said FIR filed by respondent number one.
Who is appearing for respondent number one? What is to be done? What is your submission? What should we do?
Lordship, maybe 1 week may be granted to them to
Okay. Okay. Heard Mr. Mugaka,
Yes.
the learned counsel for the petitioner. State respondent, Mr. Mohamchan will be appearing. Who will be appearing? Mr. Tibafom appeared. You represent today.
Maybe some of my colleagues, but I'm here today.
Okay. Mr. Mohamchan, learned senior government counsel, appears on behalf of Mr. E. Tibafom. None has appeared for respondent number one. Though on last occasion, the respondent number one took time to file affidavit in opposition. Stop. Considering the fact that respondent number one is not represented today, this matter is adjourned for a week. Let this matter be listed after a week on a date to be fixed by the registry.
Obliged.
For orders, item number 6.
Pleasure, Lordship. Lordship, I'm representing the respondent contingent number 2 and 3. That is the engineering chief and chief engineer. Now, last week, I was been informed by the department to file an appeal against the judgment in order dated 18/7/2005. And now I am preparing that appeal, including the continuation of delay. So I pray that this contempt may come up after the appeal.
Which you have not yet filed.
I have not, maybe next week I'll file. It is almost in the finishing end. Next week I'll file. Once, if a bill fails, then it may continue. But if the appeal
But you haven't, if appeal may not even be admitted, it is barred by limitation.
No. Yes.
Yes.
You have any submission?
Lordship, on the last occasion, the respondent 2 and 3 was directed to file affidavit, Lordship. And today they have come up with this submission, Lordship. However, unless there is a
We are giving you some time. What is your name?
Nagaland Konyak.
Your name is not there, na?
Is there Lordship? 4, Noklay M. Konyak.
Okay. Heard Mr. Noklay M. Konyak, learned counsel for the petitioner. Also heard Mr. Moa Imchen, the learned senior government counsel, who submits that he has been instructed by respondent number 2 and 3 to file appeal against the order dated 18/7/2025 passed in WPC number 337/2022, along with an application for condonation of delay in preferring the appeal. As such, he could not file the affidavit in compliance today. He submits that he is likely to file appeal very shortly and hence prays for some more time for filing affidavit by the respondent number 2 and 3. The prayer is allowed. Let this matter be listed after
Lordship, after 3 weeks.
3 weeks.
Obliged.
Much obliged.
From the supplementary cost list for hearing item number 10.
By me, Lordship.
Yes, where is the impugn order?
Lordship, the impugned order is in Annex 8, Lordship, which is paged as from page number 51 to 56, Lordship, of my petition. From page number 51 to 56, Lordship of my petition.
Yes.
Lordship, if I may just read the operative portion, Lordship, of the order.
No,
Heard both the
you,
parties at length. Defendant number 3.
no.
Yeah. Lordship, if I may be allowed,
You read the entire order. Completing. Which will give us some idea.
Lordship,
Thereafter, you make your submissions.
on page number 51, Lordship.
Yes.
Counsel for the plaintiff, Shri Nikato Watsa present. Counsel for applicant defendant, Shri Joshua Shaki present, and submitted that under provision of Order 1, Rule 10, subsection 2, the learned court has the power to strike out or to add any party at length of the proceedings, at any stage of the proceedings, either as plaintiff or defendants in the interest of justice. The learned counsel submitted that the present project sanctioned by the Government of India under the CRIF project has no provision for land compensation. The project is approved only when there are no disputes in relation to claims of land compensation. In the present case, the respective village councils issued the no objection certificate, and the same was forwarded to the Government of India, Ministry of Road Transport and Highways Planning Zone. Accordingly, the fund was sanctioned and the present applicant, defendant number 3, was awarded the work order. It is the contention of the counsel for the applicant plaintiff that the contractor is not a necessary party in the present case. Because a contractor is not the authority to compensate.
Who is the you are the plaintiff.
Lordship, plaintiff,
Perhaps that is a typo error, Your
There
Lordship.
was
It
a
should have been the
typographical error,
applicant
yeah.
defendant, my lord.
Yes, it should be applicant defendant.
yes, Lordship.
Yes.
Because a contractor is not the authority to compensate any of the landowners, including the present plaintiffs. If the plaintiffs have any grievances, the same can be taken up with the state as well as the union government, in which the contractor has no role to play or no say. The learned counsel submitted that when the materials on record are crystal clear and has no ambiguity whatsoever, the continuous presence of the applicant defendant in the present case amounts to punishing the contractor for no fault of his. It is further submitted that the discretionary power of this court can be exercised at any stage if at all the presence of the defendant is required. If at all the presence of the defendant is required. Therefore, In the interest of justice and to avoid the abuse of the process of the court, the name of the defendant number 3 should be struck out from the case and the defendant should be recused from appearing in the case any further, unless requirement in the interest of justice is felt or is to be called for by this court at any stage of the proceeding. The learned counsel also submitted on his own behalf that by order dated 7/4/2025 in FAO 1 of 2024, he withdrew the petition before the Honorable High Court with the hope that the contesting parties would join the negotiating table for amicable solution. However, it is up to the
This
parties.
appeal was against what?
It was against the injunction, Lordship.
Okay. Injunction was granted or refused?
It was granted, Lordship, in my favor. Lordship.
What injunction?
The temporary injunction, Lordship.
What was directed?
Not to proceed with the work, your lordship.
Okay, not to proceed with the work.
In
With
a
the
particular area,
development
Lordship,
works, yes,
where
Lord.
my property is situated, Lordship.
But now the work
It's proceeding, Lordship.
it is complete.
It is not complete, Lordship. I believe it is.
I think it's
under
still
progress.
continuing, and this year, because of the inclement weather, your lordship, if not, work should have been finished.
It relates to this main road.
Yeah, it relates to the road construction, your lordship. I do not know whether my lord has been to Mokokchung.
No.
After crossing Waka, there is a Doyang River. So next to the Doyang River, it goes to the particular stretch of road. It goes towards Tuinsang also to parts of Zeneboto district, your lordship.
Okay.
It is actually it's a lifeline for even people from Tuinsang. If this road is approved as a national highway, your lordship, road to Tuinsang will also be greatly shortened by this road, your lordship.
Okay.
My lord.
Then
If I may be able to.
read.
The learned counsel also submitted on his own behalf that the order dated 7/4/2025 in FAO 1 of 2024, he withdrew the petition before the Honorable High Court with the hope that the contesting parties would join the negotiating table for amicable solution. However, it is up to the parties to settle, which apparently did not happen. The same cannot be the ground to deny the defendant in filing the present interlocutory application. He reiterated his submission by stating that in appreciation of the materials on record before this court has the discretionary power to strike out or to add any party. Therefore, the contractor who has no role in the issue of the claim of compensation, the name of the defendant number 3 be struck out from the case under the given present circumstance. On the contrary, learned counsel for the plaintiff submits that the question of non-joinder of necessary party has never been contended by the defendant before this honorable court or before the Honorable Gauhati High Court Kohima bench, despite the civil suit being filed in the year 2024. Furthermore, he submits that the respondents had withdrawn his application in FAO 1 of 2024 and Civil Revision 15 of 2024 before the Honorable High Court Kohima bench, after submitting that he will make all endeavor for negotiable settlement with the plaintiff vide order 7/4/2025. The learned counsel submits that the respondents is a necessary party upon reference to his preliminary objection filed before this court bearing Civil Suit 1 of 2024. It is admitted fact by the defendants in para 5 subclause 2 of the preliminary objection that they had on their own and willfully decided to pursue for the fund under the CRAF 2000. Consequently, upon which the 6 village councils had issued the non-incumbrance certificate dated 23/6/2020. It is also submitted that it can be inferred from para number 5 subclause 2
What
and
it
3.
means,
Lordship,
that they have willfully decided to pursue for fun.
it was there in the preliminary objection, Lordship, submitted by the defendants, stating that they had pursued this fund, Lordship. It was submitted, Lordship, in the particular paragraph, which I will come to later, Lordship. I've already annexed, Lordship. Of the preliminary objections filed by the defendants in Civil Suit 1, 2024, that it was only upon the pursuance, the concerned village councils were also arrayed as defendants in the instance suit. In the instance suit had issued, and the instance suit had issued, Lordship, there are typographical errors here. And the village councils had issued the non-incumbrance certificate. thereupon which the Government of India, the Ministry of Road Transport and Highways, New Delhi, by letter 23 to 2023, had addressed to the Government of Nagaland, sanctioning the fund to the project under CRAF. The Learned Counsel also submits that it is of utmost importance to make a mention of para 6 subclause 2 of the preliminary objection submitted by the defendants in Civil Suit 1 2024. It can be made out in para 6 subclause 2 that had the land in question not been given for free, the project would have never been sanctioned in the first place. It can be ascertained from the applications filed by the defendants before this honorable court in Civil Suit 1 of 24 that the defendants had pursued the fund, thereupon which the village councils had issued the non-incumbrance certificate, and following which the government authorities had also issued necessary clearances only after obtaining NOC from the concerned village councils. Consequent upon the act of the defendant, the village council and the state machinery issuing necessary clearance, the Government of India Ministry of Road Transport and Highways had sanctioned the fund under CRAF. It is submitted that in perusal of the admissions made by the defendants before this honorable court, there is not an iota of doubt that the defendant is not a necessary party. The Learned Counsel also brings to the notice of this honorable court that in the preliminary objection filed by the defendant village councils, they have admitted that the defendant shall compensate for loss and damage incurred by the landowners. The Learned Counsel further submits that the instant IA bearing 3 of 2025 filed by the defendants before this honorable court is frivolous in nature and is aimed only to curtail the liberty of the plaintiffs as enshrined in Article 21 and 300A of the Constitution of India. The Learned Counsel submits that the defendant is estopped by the rule of estoppel. The Learned Counsel further submits that the defendant is a necessary party under the procedure established by law and for which his name cannot be struck out as his impleadment is necessary for this honorable court to effectually and completely adjudicate upon and settle the questions involved in the instant suit. It is also prayed to this honorable court and leaves its discretion to add or implead the Ministry of Road Transport and Highways Government of India as a party to the suit. The Learned Counsel further submits and prays that the instant suit filed by the defendant be dismissed with exemplary cost. In the counter submission, the Learned Counsel for the defendant number 3 clarified that para number 5(2) of the preliminary objection, there is no language whatsoever that states or admits that the defendants influenced the village council. Further, the plaint filed by the plaintiffs made no pleadings to that effect. Secondly, on the submissions of the Learned Counsel for the opposite party, that the village council's opposite party, defendants number 4 and 5, in the preliminary objection, admitted to pay compensation to the plaintiffs by the contractor. The Learned Counsel referred to para number 5, subclause 8 of the preliminary objection and the annexure number 8. The Learned Counsel submitted that the help is extended only in relation to the damage of properties and not land compensation. He submitted that such grievances, if any, can be taken up with the respective village councils, and accordingly, the contractor shall compensate on verification. Hurts both the parties in length. Defendant number 3, MSLPS's Infra, Nagaland, agreed to the agreement of Joint Council Coco Area Wide 3/2/2024. Hence, defendant number 3 be struck out from the instant civil suit 1 of 2024 under Order 1, Rule 10(2) CPC.
What is this agreement of joint?
Lordship, this agreement, Lordship, if I may, is Lordship, the affidavit in opposition, Lordship, of my learned friend, Lordship, page number 85, 58 to 59, Lordship, the affidavit in opposition submitted by the defendant's Lordship. It is there, Lordship, page number 58 to 59.
Is what is
If I may read, Lordship, the translated copy of the meeting resolution. It has been resolved that no individual or outsider shall interfere or obstruct with the road development from Coco Road to Doyang Road and Imloto IB Road. It has also been resolved that if any landowners who are aggrieved shall settle the issue with the concerned contractors individually, any help with regard.
where are you reading?
Yes, Lordship.
Which page?
From the affidavit in opposition.
Lordship, page 61. my lord.
61, Lordship.
51.
61.
Of my affidavit, my lord.
If I may read, Lordship.
Yes.
I'll begin, Lordship. It has been resolved that no individual or outsider shall interfere or obstruct with the road development from Koko Road to Doyang Road and Imloto IB Road. It has also been resolved that if any landowners who are aggrieved shall settle the issue with the concerned contractor individually. Any help with regard to damage of buildings, terrace fields, fruit farms, and plantation shall settle with the concerned contractor. Apart from that, no land compensation will be paid as per the resolution which was made before the approval of the project, wherein the NOCs were issued for construction of the road. This was signed by the chairman, Joint Council Koko Area, and the secretary, Joint Council Koko Area, Lordship. It was before the approval of the contract, Lordship. The NOCs were first submitted. Now, Lordship, if I may come to my application, Lordship. Lordship, we the revisionists, Lordship, we have our property, Lordship, located at Pilimi Village. Pilimi Village, Lordship, Krimitomi Village. It is in para number 3, Lordship, my petition. Pilimi Village, Krimitomi Village, and Rotomi Village, Lordship. These are under Authorised subdivision, Lordship, falling under Zeneboto district, Lordship. These lands, Lordship, few of them are ancestral, Lordship, and few of them are self-acquired properties, Lordship. Lordship, the ownership of these properties, Lordship, are not disputed, Lordship. The right, title, and interest of these owners, Lordship, are never in dispute, Lordship, by the village councils or by the defendants, Lordship. The village councils are also defendants, Lordship, in the main suit pending before the Zeneboto court, Lordship. It is not in dispute, Lordship. But, Lordship, the 6 village councils, Lordship, the 6 village councils, Lordship, in, if I may, Lordship. Very next to. Lordship, page number 19 to 24, Lordship. The NOCs are there, Lordship. The 6 village councils, Lordship, dated 11/10/2022, Lordship. Page number 19, Lordship. 19 to 24, Lordship. These are, Lordship, if I may. These are villages of Litsami village, Lordship. One is Litsami village, Lordship, which is in page number 19. Imlomi village, Lordship, which is in page number 20. Yeshiltomi village, page number 21. Krimto village, page number 22, Lordship. Rotomi village, page number 23. And Pilimi village, Lordship, in page number 24, Lordship. The formats are the same, Lordship. The non-encumbrance certificate formats are the same. If I may read, Lordship.
Yes.
This is to certify that the proposed project improvement of road from NH61 Doyang Bridge Koko Road to Kheloje Polytechnic Atoizu via Askuto EAC headquarters and Imloto IB British Bungalow falls under the jurisdiction of Litsami village and all others, Lordship, from 15 kilometers to so-and-so. The entire land needed for the road project is free from all encumbrance and the land shall be made available free of cost, Lordship. Lordship, as I've already mentioned, there is no dispute as far as the ownership is concerned, Lordship. But Lordship, write the NOC dated 11/10/2022, Lordship, without my consent, Lordship, without the consent of the landowners, ownership, Lordship. This land, Lordship, was taken away from me, Lordship, without my consent, Lordship. I was dispossessed of my land, Lordship, being aggrieved by this, Lordship, being aggrieved. And after this, Lordship, what happened was, Lordship, the contract, Lordship,
Yes.
yes, Lordship. After the issuance of the NOC, Lordship, the contract, Lordship, contract order, Lordship, for which I have mentioned in my petition, Lordship, it is in Annexure 4, page number 18, Lordship. page number 18. Page number 18 of my petition, Lordship. Yes, Lordship.
Yes.
This is the contract, Lordship, which was awarded to the present defendant, Lordship, LPSS Infra, Lordship. In Lordship, work order number, white work order number CE RNB COCO CPA / CIF / 2022 to 2023 /37 / 267 to 71, dated 18th of December 2023, Lordship. By this order, Lordship, my property is not disputed, but Lordship, my property was snatched away from me, Lordship. NOC was issued without my consent. And after that, Lordship, work order was issued, Lordship. Work order was issued to the present defendant, Lordship. Being aggrieved by this, Lordship, being aggrieved by this actions of the defendants, Lordship, what I did, Lordship, I had filed a civil suit, Lordship, Civil Suit 1 of 2024, before the Honorable District Judge Zinevoto, Lordship, for claiming a compensation amounting to rupees 3,86 lakhs 50,160 only, Lordship. This I had filed, Lordship, before the Honorable District Judge, Lordship, White Civil Suit 1 of 2024, Lordship, which is marked as an extra 6 in page number, from page number 25 to 42, Lordship. 25 to 42.
Yes.
Yes, Lordship. This I had done, Lordship. Thereafter, Lordship, the defendant's, Lordship, had filed IA. I filed in 2024, Lordship, but in 2025, Lordship, the defendant's, Lordship, had filed IA number 3 of 2025 before the District Judge Zinevoto, Lordship, seeking to strike out the name as defendant number 3 in Civil Suit 1 of 2024, Lordship, under Order 1, Rule 10, Lordship. I've marked and annexed the petition as Annexure 7, Lordship, which is in 43 to 50, Lordship. Lordship. Thereafter, Lordship, the impugned order, Lordship. Thereafter, the impugned order, which I have just read out before this court, Lordship, was passed on 13/6/2025, striking out the name of the defendant's, Lordship, in the instant petition, Lordship. Lordship, surprisingly, Lordship, the defendant's, Lordship, had never stated before the court, though it was filed in 2020, I had filed in 2024, Lordship, since I was aggrieved, but the defendant's, Lordship, had never come up before the court, Lordship, or before this Honorable High Court, Lordship, stating that they are not a necessary party, Lordship. Only after, Lordship, only after withdrawing their FAO, Lordship, which I had earlier mentioned, Lordship, after withdrawing the FAO 1 of 24 in Civil Revision 15 of 24, Lordship, wherein, Lordship, that stated that they will make all endeavors to amicably settle the matter, Lordship. Only after that, Lordship, after submitting that this matter will be amicably settled, Lordship, they had filed the IA, Lordship, for striking out their name as defendants in the instant suit. This was never mentioned, Lordship. 24 had filed, Lordship. Preliminary objections were also filed, Lordship. It was brought before this Honorable High Court, Lordship, for the injunction.
Yes, Ms. Pachu, CPC.
Yes, Lordship. It was never brought before any court, Lordship. Only after they had withdrawn, stating that there will be an amicable settlement, Lordship, they had filed the instant suit for striking out the name, Lordship. Lordship, if I may read the order of this Honorable Court, Lordship. It is in from page number 57 to 61, Lordship. This was order dated 7/4/2025, Lordship. If I may read, Lordship, the orders passed by this Honorable High Court, Lordship.
Yes.
Page number 60, Lordship. I am page number 60. Mr. Joshua Shaki, the learned counsel appearing on behalf of the appellants in FAO 1 of 2024, as well as the petitioners in Civil Revision 15 of 24, submitted that as the issues involved in the instant suit pertains to certain land being required by the village council for the purpose of construction of the road, which is for the betterment of the public. Endeavors, your lordship, endeavors shall be made to have a negotiation with the plaintiff, who are the respondents herein, and as such would not like to press both the proceedings before this court. Taking into account the above, both the proceedings stands closed on withdrawal. Interim order passed earlier sustained vacated. In view of the withdrawal of both the proceedings and the vacation of interim orders, the parties who are duly represented shall appear before the learned trial court on 2/5/2025 for further proceedings of the civil suit 1 of 2024. It is, however, observed that the pendency of the suit shall not bar the parties to arrive at a negotiable settlement. The records of the civil suit 1 of 2024 shall be returned forthwith, lordship. This is the order passed by this honorable High Court, lordship. Only after this, lordship, without even lordship taking an initiative, lordship, to settle the matter, that filed an application, lordship, surprisingly, lordship, that filed an application before the district court, lordship, seeking to strike out the name, lordship. We have never been approached, lordship. We have never been approached. And also, lordship, I submit to this court, lordship, we are not adverse to any developmental activities, lordship. We are only here raising our concern, lordship. We are only here raising our rights, lordship, as the rightful landowners, lordship. Our land was, lordship, dispossessed from us illegally, lordship, without my consent, lordship. There was no consent. Though the right title and interest is in this undisputed, lordship, there was no consent. Also, lordship, I would like to come back to my submission, lordship. The Honorable District Judge, lordship, has failed, lordship, to decide the fact in issue. The observation, lordship, just states that basing on the Coco agreement, lordship, they have been struck off. The fact in issue was, lordship, whether the defendants were a necessary party or not, lordship. There's no observation as to such, lordship. If I may read, lordship, if I may reiterate once more, lordship, the order, lordship.
Yes.
Page number 25, lordship. Page number 51, lordships. From page number 1 to 56. It is in page number 56, lordship, the relevant portion.
Yes.
The observation of the district judge, the honorable district judge, lordship, heard both the parties at length. Defendant number 3, LPS's infra, so-and-so, agreed to the agreement of joint Coco Council area wide dated 3/2/2024. Hence, the defendant number 3 be struck out from the instant civil suit under Order 1, Rule 10. Lordship, the question of a necessary party, lordship, has not been decided, lordship, has not been looked into. The fact in issue was the necessary party, lordship. I had stated, lordship, that the defendants are necessary party, lordship. The orders are very clear, lordship. There was no observation made as to necessary party, lordship. The court has decided only upon an agreement where the contractor shall compensate for any damage, lordship. Though my land, lordship, I was displaced of my land, they shall pay a compensation only for damages if there were any plantations or if any households were damaged. Lordship. Lordship, the lordship was inquiring about para number 5 and para number 3, lordship, of the preliminary objections, lordship, earlier. If I may take you there, lordship.
Yes.
Page number 62 to 69, lordship. Lordship, if I may read, from page number 64, lordship.
Yes.
It is in para number 5, lordship, subclause 2, lordship, subpara 2. Has your lordship got it?
Yes.
May I read, lordship?
Yes, please.
The answering, this is the preliminary objection, lordship, of the defendants. The answering deponent, in order to widen and improve the present road with the main concern for the people of Zinaboto district, to have an alternative good road, decided to pursue for the fund, Lordship, under the Central Reserve, under the Central Road Infrastructure Fund, CRIF Act 2000. Consequently, Lordship, the Philimi Village Council issued the non-encumbrance certificate dated 23/6/2020. The Rotami Village Council, the Krimtomi Village Council, the Litsami Village Council, the Imlomi Village Council, and the Yeshultomi Village Council issued a non-encumbrance certificate dated 23/6/2020. The non-encumbrance certificate on affidavit paper was issued by the Philimi Village Council, Rotami Village Council, the Krimtomi Village Council, the Litsami Village Council, Imlomi Village Council, and the Yeshultomi Village Council, and countersigned by the SDO Civil Authorised dated 11/10/2022. All the 6 village councils offered the land in the jurisdiction for free, Lordship. Also, Lordship, the next para, Lordship, next sub-para 3, Lordship, in page number 65. Consequent upon receiving clearance from all the stakeholders in the favor to widen and better road, the Government of India, Ministry of MORTH, New Delhi, white letter dated 23 February 2020, addressed the letter to the Government of Nagaland, sanctioning the fund for the present project under CRF, Lordship. Lordship, it is crystal clear, Lordship, from the preliminary objections, Lordship, submitted by the defendant, that they had pursued for the fund, Lordship. Thereafter, Lordship, the village council, Lordship, had issued the non-encumbrance certificate, Lordship. And then, Lordship, sanctioning was made, Lordship. It is very clear, Lordship, that the defendant number 3, the defendant here, Lordship, who is the contractor, is a necessary party, Lordship. Because this is his affidavit, Lordship.
Who will be paying compensation to you?
Lordship, the compensation, Lordship, I am seeking from the village council and from the defendant's, Lordship. Since the village council has issued.
No, who is constructing the road?
The contractor, Lordship, LPS.
No, contractor is doing the work for someone.
Yes, Lordship. The contractor is working for the state, Lordship.
Yes.
It was awarded by the state, Lordship.
So it is for the state. In the civil suit, whom have you made party?
I've made the state a party as well, Lordship. I'm only aggrieved by the fact that.
But not the sanctioning authority, that is the Government of India, madam.
Herein, Lordship, I've made the state a party as well, Lordship, but I'm only aggrieved by the fact that the defendant, the present defendant, Lordship, the contract has been struck off, Lordship. Because, Lordship, without the presence, Lordship, it cannot be adjudicated, Lordship. If I may, Lordship, come back to my submission.
Yes.
Lordship, I would like to take this court to para number 16 of the same affidavit in opposition, which is in page number 66, Lordship.
Yes.
Why we contend that these are necessary parties, Lordship. Para 6, sub-para 2, Lordship, in page number 66.
Yes.
In addition to the fact that there is no provision for land acquisition under CRA Act 2000 in the nature of the present project, the concerned village councils representing the interest of all the plaintiffs have issued non-encumbrance certificate, and the government authorities have also issued necessary clearance as per the established procedure of law. The 6 villages, for want of development, have unequivocally provided the land for free. Lordship, this is very important, this next paragraph. If land acquisition, land compensation is insisted, the project would never be sanctioned in the first place. Without establishing the case within the parameters of law, no relief can be sought or granted, Lordship. The affidavit in opposition is also very clear, stating, Lordship, if the land was not given for free, Lordship, this project would have never been sanctioned. And Lordship, in the foregoing paragraphs, Lordship, it has been mentioned that they had pursued for the fund, then the non-encumbrance certificates were issued. And if you had sought for compensation, then this will not be sanctioned in the first place. We are not against development, Lordship. I am only here asserting my right, Lordship. Asserting my right,
Okay.
Lordship. Lordship, another reason, Lordship, why I say that the defendants are necessary party, Lordship, can be derived, Lordship, from Annexure 12 of my instant petition, Lordship, which is from page 70 to 71, Lordship. Seventy to 71, Lordship. Has the Lordship got it, Lordship? Page number 71. If I may read the translated copy of the resolution, Lordship.
Yes.
This is dated 28/1/2024, Lordship. Meeting resolution held with regard to road construction. Any damages caused to any buildings, house, and farms during the process of construction of the road has been decided for consideration. No land compensation shall be given as per the DPR. Any damages to the property's plantation shall be compensated by the contractor. The GBs will take the initiative to supervise the construction of road till the completion of the project. Retaining walls and culverts will be constructed by the landowner. Request has been made to blacktop the road from Akutuka to Arukutsubo. It has been requested to the contractor to start work from between 1 to 2 week of first to second week of February. It is signed by the chairman. Lordship, the contractor shall not compensate for the land, but shall compensate for the damages. Lordship. Lordship, if the contractor is not a necessary party, Lordship, as this court has rightly pointed out, Lordship, why is the contractor, Lordship, willing to even compensate for any damages, Lordship? It is for the state to compensate, Lordship. It is not for the contractor to compensate. The Lordship, without impleading the contractor, Lordship, the orders cannot be passed against him, Lordship.
Okay.
So, Lordship, on these grounds submitted, Lordship, it is amply clear that defendant number 3, Lordship, that the present defendant, Lordship, is a necessary party, Lordship. Lordship, I would like to refer to a citation, Lordship, referred to in by the Honorable Supreme Court, Lordship, in order to contend my submission, Lordship. Lordship, for easy reference, Lordship, I have marked the paragraphs, Lordship.
Para number?
Lordship. It is from para number 17, Lordship, of page number 4, Lordship. I have marked it for easy reference, Lordship. Who is a necessary party, Lordship? The Honorable High Court, the Honorable Supreme Court, Lordship, has decided who is a necessary party. Lordship, para number 17, Lordship. May I read, Lordship?
Yes.
This court, in the case of Mumbai International Airport Private Limited Supra, has observed thus: a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit, though he need not be a person in favor of or against whom the decree is to be made. If a person is not found to be a proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in the suit property after the suit is decided against the plaintiff will not make such a person a necessary party or proper party to the suit or for a specific performance. Lordship, para number 18. It could thus be seen that a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. It has been held that if a necessary party is not impleaded, the suit itself is liable to be dismissed. Lordship, the next page, Lordship, page number 5. Yes, Lordship. The referring paragraph 7 and paragraph 20, Lordship. If I may read, Lordship.
Yes.
From the above, it is now clear the two tests are to be satisfied for determining the question who is a necessary party. Tests are: there must be a right to some relief against such party in respect of the controversies involved in the proceedings. No effective decree can be passed in the absence of such party. Para 20, Lordship. It can thus be seen that what has to be held by this court is that for being a necessary party, the twin test has to be satisfied. The first is that there must be a right to some relief against such party in respect of the controversies involved in the proceedings. The second is that no effective decree can be passed in the absence of such a party. Lordship, As I had mentioned, Lordship, in the resolutions as well, Lordship, the contractor, Lordship, though Lordship stating that they will not compensate for a land acquisition, Lordship, had stated they are willing to compensate for the damages, Lordship, in lieu of the work. Lordship, I have a right there, Lordship, and they have a duty, Lordship, to compensate me. They have already admitted, Lordship. Also, Lordship, without making the defendants, Lordship, the contractor, no effective decree will be passed, Lordship. If at all, Lordship, they have to compensate for any loss, or for a matter of fact, for the acquisition, Lordship, orders cannot be passed against him, Lordship. So, Lordship, on these grounds, Lordship, I have a very limited prayer, Lordship, that the order, Lordship, passed by the Honorable District Court, Lordship, in dated 13/6/2025, Lordship, maybe, Lordship, set aside, Lordship. This is my limited prayer, Lordship.
Yes, Mr. Shi. Who is constructing the road?
My lord, it is the project under the CRIF. And my lord, this is after the fund was provided for by under the CRIF, the MORT, Ministry of Road Transport and Highways.
So Ministry of Road Transport and Highways is the agency.
Yes, your lordship, they are a funding agency.
Who is
Well,
monitoring?
The monitoring is done by the PWD, your lordship,
State.
the state, your lordship.
But how you can take private land without giving any land compensation?
Now, your lordship, here, I will satisfy your lordship and I'll try to make it as brief as possible, your lordship.
Yes.
First,
The question is very limited. We are
Yes.
not going into questions of rights. The question is whether the presence of the defendant, respondent is necessary
your lordship,
or
It is not necessary.
is required.
it is not required, your lordship. In fact, since my learned friend has given an elaborate submission, the first point I'd like to present before your lordship is the litigation itself is frivolous in the first place, your lordship,
Why?
because the village councils, your lordship, there is a village council system in Nagaland, my lord.
No, but they are challenging that village council gave the non-encumbrance certificate without
Yes,
consulting the.
that is the issue they are raising, your lordship. But just because the non-encumbrance certificate was issued by the village council to the contractor, your lordship, here, how is the contractor responsible for that? The village council is not under the contractor, your lordship. Their grievance, if they have any, is against the village council. They fully know, everyone is fully aware that under the CRIF fund, under the CRIF Act 2000, your lordship, there is no provision for land compensation.
Where is that CRIF Act?
Your lordship, I will take your lordship to page 19, your lordship, of my affidavit in opposition. The lordship, may I take your lordship to the page 24, annexure B, your lordship, the relevant portion, your lordship.
Page 24.
My lord, page 24. Has my lord seen? Para 9. The estimates of land acquisition.
What is this? This is.
Your lordship, this is issued by the Ministry of Road Transport and Highways.
No, what is this? These are executive directions or what?
Yeah, this is under
Is
the CRIF Act, my lord. The estimate of land acquisition shall be allowed for development of national highways, estates, UTs, contributions to share of land costs. However, this is important, this part is important, your lordship, relevant.
Right.
However, estimates for land acquisition shall not be considered for any other projects except for items referred to in serial number 4 of sub-para 1 of para 5. This, we're talking about the national highways, your lordship. And the executive agency in the state or union territory shall render a certificate to the effect to the state government UT concerned that land is available for road development and is in its possession and removing of utilities, if any, has been completed for such works. So, my lord, except for national highways.
Then state may have to pay.
Yes, your lordship.
Under this CRIF, state has to give an assurance
Yes,
to the funding agency that land is available.
yes, your lordship.
That does not mean land will be available free of cost. State has to acquire the land from the owner.
Your lordship. No, my lord.
Therefore, he has approached the court seeking compensation from the state.
Your lordship. But here, your lordship, the target is the contractor, because your lordship, the contractor is from Rotomi village. And even the applicant number one, the petitioner, he is also from Rotomi village, your lordship. Now, just because the contractor out of the way, because he's from this very area, he decided to compensate for the property damages. He's doing good works and he is being blamed for offering his services free of cost, your lordship, in addition to the whatever benefits or not that he can extract from the execution of this work. He is willing to compensate and he's being blamed for that, your lordship. How ridiculous is that, my lord?
That may be decided in the suit.
Yes, your lordship. So, my lord, here.
But unless you are party there, how will you put your defense? Have you filed a written statement?
Your lordship, in fact, I have met.
You took preliminary objection and then.
I have just pointed out few points in the preliminary objection. The reason why my learned friend was earlier pointing out why I filed the petition under Order 1 Rule 10 at a belated stage. It can be at any stage, my lord. In the first place,
statement has been filed.
A written statement is yet to be filed. In fact, I have more preliminary objections also to be raised, my lord, but on limited grounds.
You have limited time to file written statements.
Your lordship.
Statute provides for a.
My lord, but there has been this continuous litigation, your lordship, from the district court to the high court and back.
And in high court, you have assured that.
Yes, and it is a lie that no effort was made, your lordship. What the petitioner wants is he wants to execute the work himself. The contract itself, he wants it, your lordship. But that I will not be going into the details because that's a personal issue between them. As a counsel, it is not my lookout, my lord. But here, my lord will kindly appreciate the participation of the contractor in the case in the first place without going into all the details of whatever laws have been satisfactorily pleaded or has not been, your lordship, was not the main lookout. The first desire of the present, your lordship, respondent was to see that there was an amicable solution. He even went out of the way, deciding to shoulder the responsibility of allowing the landowners to do some minor works, which does not require much of an expertise, knowledge in terms of constructing the culverts and retaining walls, your lordship, and even to compensate for whatever property has been damaged. This is not his lookout, but he decided to do that out of the way because he is from this area and he wants to ensure that with this fund, the road will be constructed because this is not only a lifeline for these 6 villages, your lordship. It reduces at least 20-30 kilometers or more than that also, your lordship. It shortens the journey for so many villages under Zinemoto district.
No, that is not the issue before.
Yes, your lordship. I got your lordship.
Nobody is disputing.
Yes, your lordship. Now, my lord, here. Now, even assuming that the plaintiff succeeds, what is he going to get from the contractor? He's going to get nothing. He's getting nothing, my lord. So when the contractor has even gone out of the way to agree to the villages concerned that you should pay for the damages, he has agreed, even though it is not his lookout. He has agreed to even allow them to construct the minor works like the culvert and then retaining walls, your lordship. Now, beyond that, my lord, the contractor is not responsible for the action of the village council. The contractor is not responsible for the action of the state, your lordship. He is only executing the work. Now, when, as my learned friend has already referred to one apex court decision, the point number 1, your lordship, what relief? There should be a relief that can be claimed from the party who is struck out from the case, your lordship.
Yes.
So, my lord, even the authority is in my favor, my lord. So even at any stage, if I have to be recalled by the learned trial court who has exercised his wisdom in passing that order under Order 1, Rule 10, Subclause 2 of the CPC, Your Lordship, if I'm recalled at any stage, my Lord, I'm willing to cooperate. But my Lord, instead of allowing me to peacefully execute the work for the public, Your Lordship, I have been harassed by dragging me into the case also as the main respondent, Your Lordship. The target is me, not even the village council or the state, my Lord. Then what relief can be sought from me as a contractor, my Lord? So, Your Lordship, it is my respectful submission, without going into other details, my Lord, that striking out the name of the contractor is fair, Your Lordship. At any stage, if I'm recalled back, I can go back and participate. Your
No,
Lordship.
but suppose you are not necessary party, assuming that you are not, no relief can be, but you are executing the work.
Yes, Your Lordship.
So are you not a proper party in the claim by the applicant?
Your Lordship, in this case, I
In
would,
your absence, how the court will decide? Trial court will decide.
no, Your Lordship, if,
You may not be giving relief. Maybe state may be liable to give relief, that we cannot give compensation. At this stage, we cannot say. But because you executed, and the reasoning of the trial court is that only because of the COCO.
yes, Your Lordship, my agreement to allow them to do work and also to compensate them for the
And
losses.
only for that reason it was allowed.
Yes, Your Lordship, legal reasoning, reasoning in law is not given, my Lord. Your Lordship.
You are agreeing to that.
No, what is on the record, my Lord, on the face of the record, I cannot say anything more than that, my Lord.
Heard, Mr. You have
Nikato, what's that, Lordship?
heard, Mr.
Just leave it.
Nikato, what's up?
Nikato
What's up?
Otsa. Heard Mr. A. Nikato Otsa, learned counsel for the petitioner. Also heard Mr. Joshua Sheki, the learned counsel for respondent number 1. This application is under what provision? 115 or 227?
227, Lordship.
This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 13/6/2025 passed by the Court of Learned, District Judge.
I beg your Lordship's apologies.
Yes.
My Lord, before my Lord concludes the dictation, may I take your Lordship to para 13
Of
Roman 18 of my of my affidavit in opposition, my Lord. I have made one specific request, assuming that this petition is to be allowed, my Lord. Page 13, Roman 18, my Lord. May I read, my Lord?
just a minute, just
My Lord.
it is difficult to flip pages. Yes.
Assuming that the present civil revision petition before this Honorable Court is allowed, the present deponent will naturally file a proper written statement taking all the grounds, not challenging the basic orders, that is the decisions of the village council, not impleading mode as a party, not challenging the CRIF Act 2000, and not challenging the mode letter dated 31/1/2020 and mode OM dated 31/1/2020 before a learned court below. So, my Lord, I may be allowed, given an opportunity to file an elaborate written
No, there is
statement, if,
no,
assuming that this is allowed.
there is no bar in filing written statement, but that has to be decided by the trial court.
Your Lord.
Whether, because your written statement is beyond statutory period, 90 days have lapsed.
Your
They
Lord.
can take that plea. That has to be decided by trial court.
My Lord, Your Lordship.
क्या लिखा?
My apologies, Your Lordship.
Zunepoto in interlocutory application number 3/2025 registered in connection with civil suit number 1/2024, whereby the trial court allowed the prayer for striking out the name of defendant number 3 within bracket present respondent number 1 from the civil suit number 1/2024. Stop. Mr. Atoka. Mr. A. Nikato Wotsa, the learned counsel for the appellant, learned counsel for the petitioner, has submitted that the petitioner there are how many petitioners?
3, Lord.
Learned counsel for the petitioners, plural, are the absolute owner of plots of land situated in Filimi village, Krimtomi village, and Atoizi town. He submits that the land of the petitioners has been allowed to be utilized for executing the work of construction of which road construction in pursuant to the work order issued to the present respondent number 1 bearing work order number CE within bracket RNB slash COCO KPA slash CRIF slash 2022-23 slash 37 slash 267 dash 71 dated 18 December 2023 without taking any consent or approval from the present petitioners who are the rightful landowner of the land over which the said construction work is carried on. Stop. He submits that since the petitioners have been illegally dispossessed of their land for the purpose of the aforesaid project, that too without paying any compensation, the petitioner approached the Court of London District Judge Zuneboto by filing a civil suit seeking compensation for illegal acquisition of their land by the respondents. The said civil suit was registered as civil suit number 1/2024. He further submits that in the said civil suit, the petitioners have made the state government, the concerned village council, and the contractor, that is the present respondent number 1, as defendants. Stop. The present respondent number 1 has been made defendant number 3 has been arrayed as defendant number 3 in the said suit. He, however, he submits that, however, no, next para, learned counsel for the petitioners further submits that the petitioners also got interim relief in the form of temporary injunction under Order 39, Rule 1 and 2 for staying the execution of the
in their property, Lordship, within their property.
execution of the work of the construction of road over the properties of the petitioners in interim. No, read this line. Interim, last in interim card दीजिए. Last, read that sentence again. He further submits that being aggrieved by the order of granting interim relief to the petitioners, the present respondent number 2, respondent number 1 filed an appeal before this court and also filed a civil revision petition, which were registered as FAO number 1/2024 and civil revision petition number 15/2024. However, he submits that both the appeals as well as revision petition were allowed to be withdrawn by the court by its order dated 7/4/2025 by a coordinate bench of this court. On assurance that endeavors shall be made to have a negotiation with the plaintiffs, within bracket, that is the present petitioners, by the Respondent number one.
Respondent number one in the present petition.
By the respondent number one in the present
Present petition.
present
suit.
petition,
And defendant number 3 in the pending suit, my lord.
within bracket, and defendant number 3 in civil suit number 1/2024. Stop. He, however, submits that in spite of the said order of this court, the respondent number one never approached the petitioners for the purpose of getting the dispute settled amicably. Rather, he approached the trial court by filing an interlocutory application under Order 1, Rule 10, within bracket 2 of the Code of Civil Procedure, seeking striking out of name of defendant number 3 from the civil suit number 1/2024. Stop. He further submits that said interlocutory application was registered as interlocutory application number 3/2024. The learned counsel for the petitioner submits that thereafter, by the order which has been impugned in this revision petition, that is order dated
The impugned order is lordship 13/6/2025.
order dated 13/6/2025, passed in civil suit number. Impugned order was not passed in IA.
Lordship, the impugned orders, IA lordship, has not been mentioned here, lordship.
Not been passed in IA number 3/.
IA 3 of 2025, lordship.
3/2025 in connection with civil suit number 1/2024. The prayer of the respondent number 1, present respondent number 1, was allowed, and his name, that is the name of defendant number 3, was allowed to be strike out from the plaint of civil suit number 1/2024. He submits that the trial court, while passing, next para, the learned counsel for the petitioner submits that the trial court, while passing the impugned order, had erred in getting the striking out of name of the defendant number 3, inasmuch as it failed to take into consideration that defendant number 3 is one of the necessary parties in whose absence an effective decree may not be passed in the pending civil suit number 1/2024. He further submits that there is no dispute that the land which has been unauthorizedly occupied for the purpose of there is no dispute to the fact that the land of the petitioners over which the Doyang Bridge, Coco Road is being constituted.
Constructed, my lord.
Huh?
Is it to do with the construction of the road, my lord? The
Yes,
Coco Road. It's called the Coco Road, my lord. And my lord, my apologies. As far as the ownership is concerned, we're not disputing that. But whether it was done with or without their consent, that is to be decided by the trial court, my lord.
Doi Calica. The Dayang Bridge, Coco Road. Is being constituted. Is being constructed.
My lord.
No, yeah, line फिर से पढ़. That dispute to the fact that it is the बाकी काट दीजिए. It is the present respondent number 1 who has been awarded the contract by the Government of Nagaland PWD within bracket RNB by work order dated 18 December 2023 to proceed with the execution of the work of construction of work of improvement of road from NH 61 Doyang Bridge, Coco Road. Then Coco Road, and then you quote it from page number 18 of the petition, blue underlined portion. Stop. He therefore submits that the presence of the petitioner would be presence of defendant, present respondent number 1 / defendant number 3 would be necessary for adjudicating the dispute by the civil court in civil suit number 1/2024. He submits that even the you may take seats, both of you.
My lord.
Even the resolution adopted by village council, for example, resolution adopted on 28/1/2024 by the Filimi Village Council, indicate that any damage to properties / plantation shall be compensated by the contractor. That is the respondent number 1. As such, the respondent number 1, that is defendant number 3, is a necessary party for resolution of, for adjudication of dispute in civil suit number 1/2024. Hence, he submits that the trial court has committed wrong in allowing the application filed by the present respondent number 1 under order 1 rule 10 within bracket 2 of the CPC. He therefore submits that the impugned order is liable to be set aside and quashed. In support of his submission, learned counsel for the petitioner has cited a ruling of the apex court in the case of Moreshar Yadav Rao Mahajan versus Venkatesh Sitaram Bhedi, reported in 2022 Live Law within bracket SC 802. Stop. Before that, one more paragraph before citation. Learned counsel for the petitioner has also submitted that the trial court has also erred in passing the in allowing the interlocutory application filed by the present respondent under order 1 rule 10(2) without discussing anything in the impugned order regarding the question as to whether the respondent number 1 is a necessary party to the suit or not. He submits that a bare perusal of the impugned order would indicate that the interlocutory application filed by the present respondent number 1 was allowed by the trial court merely on the ground that defendant number 3 within bracket present respondent had agreed to agreement of joint council Coco area, which was, where is this agreement? 3-2, which was
This agreement is in the page 60 to 61, Lordship, of the affidavit in opposition of the respondent. 60 to 61 of the respondent, Lordship, from 60 to 61. The translated copy is in 61, Lordship.
क्या लिखा? Coco area dated 3/2/2024. Stop. He submits that in the said agreement, which is a meeting resolution adopted by Joint Council of Coco area, it was resolved that as regards damage of building, terrace field, fruit farms and plantation same shall be settled by the concerned contractor within bracket defendant number 3. Stop. He further submits that it was also resolved that apart from that, resolved therein that apart from that, no land compensation will be paid, which the present petitioners have questioned in their civil suits. Stop. उसके बाद in support of contention. On the other hand, learned counsel, on the other hand, Mr. Joshua Sheki, the learned counsel for the respondent number 1, has submitted that the trial court has made no error in allowing the application filed by the present respondent number 1 under Order 1, Rule 10 within bracket 2 of the CPC by force striking out the name of the present respondent number 1 as defendant number 3 from the plaint of civil suit number 1/2024. He submits that the construction of proposed road which is done by the present respondent number 1 in pursuant to the work order dated 18 December 2023 is done under the provisions, is done under the provisions of Central Road and Infrastructure Fund within bracket CRIF Act 2000. He submits that under the provision of the said Act, it is for the state government concerned to make the land available for road development. And no provision for grant of compensation is there under the said, under the provisions of said Act. He submits that accordingly, the concerned village councils have given non-encumbrance certificate in respect of the land over which the construction of road was carried on. He submits that the respondent number 1 is not a necessary party as the respondent number 1 has compensation, if any, payable to the petitioner. It has to be by either the state government or the union government. He submits that since the Respondent number one, who is a contractor executing the said work, also hails from the Coco area.
Lordship.
He offered to settle the issue regarding damage of buildings, terrace fields, fruit farm, and plantation. However, he is under no legal obligation to do so.
Your lordship.
He submits that no decree for grant of compensation for acquisition of land may be passed against a contractor who is executing the work in pursuant to the work order issued to him by the government of Nagaland. As such, he is not a necessary party, and therefore he submits that the trial court was right in striking out the name of respondent number one from the plaint of civil suit number 1/2024. He further submits that the respondent number one has taken certain preliminary objections before the trial court in the pending civil suit, and he is yet to file his written statement. However, he submits that in the event this revision petition is allowed, the respondent number one may be allowed to take all the defenses regarding maintainability of the suit and non-joinder of necessity parties and other defenses in his written statement. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered the rulings cited by learned counsel for the appellant, learned counsel for the revisionist in support of his respective submission. It appears from the materials on record that the civil suit number 1/2024 has been filed by the present petitioners before the trial court seeking compensation for unauthorized use of their land for construction of aforementioned roads. It is also not in dispute that the execution of the project for construction of road including the over the land, including the lands of the present petitioners, is being carried out by the respondent number 1 in terms of work order dated 18 December 2023, issued by the Chief Engineer, PWD, within bracket RNB, Nagaland, Kohima. It also appears that in some of the resolutions adopted by village council of the villages in which the land of the petitioners are situated, it is reflected that the present respondent number 1 would be responsible for paying compensation in respect of damages caused to the plantations and other properties over the land. Under such circumstances, the land stop. Next one. On perusal of the impugned order dated 13/5, 13 order dated 13/6/2025. It appears that the trial court has allowed the prayer for striking out the name of defendant number 3 merely for the reason that the defendant number 3 has agreed to the agreement of Joint Council Coco Area dated 3/2/2024, which provides for the which provides that in the event of any landowner aggrieved regarding damage of buildings, terrace field, fruit farms, and plantations in respect of the land over which the Coco Road to Doang Road, over which the road development work from Coco Road to Doang Road is being executed, shall be settled with the concerned contractor. So no other reasons has been stated in the impugned order for allowing the prayer for striking out the names of the respondent number 3, defendant number 3. This court, next prayer, the apex court, in the case of in the case cited by the learned counsel for the petitioners, that is namely Moreshwar Yadavram Mahajan versus Venkatesh Sitaram Bedi Supra, has made following observation in respect of the question as to who may be regarded as necessary party or a proper party in connection with a civil suit. Quote para 17 and 18 from the said judgment. Whether the defendant number 1, whether the defendant number 3 is a necessary party or a proper party, is a necessary party in civil suit number 1/2024 is for the trial court to decide. However, from the facts, from the submissions of the learned counsel for both sides, it can be held without any doubt that the defendant number 3 is certainly a proper party whose presence would enable to the civil court to properly adjudicate the dispute in civil suit number 1/2024. Stop. This court is of considered opinion that while considering the interlocutory application number, what is the interlocutory application number dash?
Number 3.
3 of 25.
3 of 2025 in connection with civil suit number 1/2025, the trial court ought to have considered this aspect before reaching a decision as to whether to allow the prayer for striking out of defendant number 3 from the said suit, from the plaint of the said suit or not. However, same was not done by the trial court, and the said reason is sufficient to set aside the decision of the trial court as decision of the trial court. Stop. Full stop. As already discussed herein before, that the present respondent number 1 within bracket defendant number 3 is certainly a proper party in the pending civil suit number 1/2024. The decision for striking out of the name of the respondent number defendant number 3 was not correct. Stop. In view of the discussions made and reasons cited in the foregoing paragraphs, the impugn order is hereby set aside, and this revision petition is allowed.
Lordship.
As regards the prayer as regards the submission of the learned counsel for the respondent number 1 that the respondent number 1, as defendant number 3 in the aforesaid suit may be allowed to file written statement. Same is left for consideration by the trial court. The respondent number 1 may make such a prayer before the trial court, which may be considered by the trial court on its own merits.
Your Lordship,
This revision petition is accordingly disposed of.
Your Lordship, in any case, if I'm a necessary party, my proper affidavit may also be helpful for the outcome of the case. So, my lord, if Your Lordship, by exercising the power under the Article 227, if a direction is issued.
Last paragraph क्या लिखा? You have any object? Yes. As regards prayer. When are you going to file?
Lordship wrote recently, just yesterday, Your Lordship, the Nevato Road has been blocked.
No,
But
when are
within
you
1
going
month-
to file the WS?
Within 1 month, I can file it, Your Lordship.
Okay. As regards पढ़ो तो फिर से. No, written statement, stop. Considering the fact, comma, considering the fact that the respondent number, that the defendant number 3 is a proper party and its presence would facilitate the adjudication of dispute by the trial court in civil suit number 1/2024. The prayer is allowed. The defendant number 3 shall file its written statement before the trial court, not later than which date?
Lordship,
Latest by
the second week of September, Your Lordship.
Date. Second week of this.
It is 7th,
latest by 11th of September
my lord. Your Lordship.
2026.
My lord.
With above observation, this civil revision is allowed. Huh? वो कर दे. Finish.
Your Lordship, the LCR may also be here, so.
Yes, let the trial court records be sent back by the registry to the trial court along with a copy of this judgment.
My lord.
So next, no orders as to cost.
Oblige, Your Lordship.